Hi, I'm Dave Dinkel. Today we're moving into our series on legal mythbusters, specifically about partitioning of a probate. As I've mentioned before, this information is for educational purposes only. It's not to be construed as legal or accounting advice. Any specific comments or questions you have, please refer them to info@myfllegal.com. Participants today are myself as the interviewer. Reach me at davedinkel.com and besttransactionalfunding.com. It's my phone number. With me today is Ryan Shrouder, Esquire, as our guest speaker of Sphinx, Shrouder, and Carnes, PA. This is Ryan, as a matter of fact. Hi, Ryan. Welcome.
Thanks for having me, Dave.
You're more than welcome. Let's talk about, in general, how does the probate process work?
Excellent question. Dave, probate is the process by which the court marshals or divides up and disperses assets after a person dies.
Okay, sounds pretty simple.
The concept's not that difficult, but the process is a little archaic and can have some intricate little ins and outs. Essentially, when you die, even if you die with a will, you have to go through the probate process, which is the court overseeing the distribution of your assets. And the reason for this is the court wants to make sure that the right heirs receive the property and that the right creditors are paid off. So anytime somebody dies, whether they have a will or not, they'll have to probate their property so that the state and the court can ultimately make sure the right people receive and inherit property and the correct people are paid off anything that they're owed.
Okay, now I understand there's two types of probates. What are those two?
There's two common types of probate. The most two common types of probate is a formal administration, which is where a full administration is done of the estate. It's the most common one, actually. It requires the most involvement and oversight of the court. And then there is also commonly used a summary probate administration. And what that is, that's a fast track probate, where instead of the court appointing an executor or a personal representative to oversee all of the assets, to bring them in, to do all kinds of different things, which obviously involve more time and money because it's almost like having a guardian appointed and involved in the process. The summary probate administration, if the situation is small enough or the person has been dead long enough, it allows the court to kind of look past all those formalities and distribute the property directly to the heirs.
Okay, you mentioned a will a moment ago. What if there is no will?
So if you have a will, the property of a dead person will be distributed in accordance with their wishes, which is included in their will. If there is not, the property is distributed and passes in a manner which they call intestate, which is dying without a will, and it would pass in accordance with the law on who inherits. So in that situation, if you passed away and you had no will, your property will pass along to your heirs, depending on your situation, but the chain of command, so to say, or the way it descends. I can give you a couple examples. If you died without a will and you were not married and you had children, your property would pass to your children. Say you died with no will and you were married, but you had no children, your assets would pass to your spouse. If you were married and you had children, the court looks at, or the law looks at, what the composition of those children are, whether or not they're all from your spouse, and whether or not your spouse had any children outside the marriage. And if you had no children outside of your marriage, and neither did your spouse, everything would pass to your spouse because the state assumes then it could then trickle down to your guys' children, which are all in common. In a situation where you did have some children that were not in common with your spouse, the court allows your spouse to get 50% and the other 50% will go to your children. So basically, it's the flow that the state has established as to who steps in line to get your property. And if you don't have a spouse or children, it goes down the chain a little more, and we can get more in depth with that, but I think that's probably for a different conversation.
Yeah, I've been involved in some where the decedent passed away 20 years ago and with no will, and his son ultimately, who had the same name except Junior, wound up on title just because he never did anything. And ultimately there was a whole chain of people in between, his decedent's wife and so on and so forth, where they all had to go back and be probated and find out who was the remainder man or woman in this case. And it took a fair amount of time and cost to do that. So how is the personal representative chosen? Let me ask you that.
Okay, so I'll start with, we discussed the two common types. You had the summary administration, which is the fast track one if you qualify, and a little bit later we'll get into that. And then you had the formal administration, which is where you have an executor or a personal representative appointed. So as to your question, how does the court decide who that personal representative is going to be or that executor? Well, if you have a will, you can name somebody who would have preference. If you don't have a will, the law establishes who would have preference or first choice, so to say, to become the executor or personal representative. And under the law, your spouse would have first preference over your children, and obviously your children would have first preference over maybe their children or somebody who is lower in the chain as them. There is some requirements. The personal representative does have to be 18 years of age. The personal representative cannot be a convicted felon. But generally speaking, your personal representative is going to be your spouse or one of your children or your highest in line heir. Whichever heir you had that has the most interest, you would often be the personal representative. And then other times, if you have a will, you might have your attorney or friend. You might name one of them as the personal representative.
So one of the common things we see is there are multiple beneficiaries and one or more of them won't agree to sell. Tell us about that.
Well, there's usually two typical situations. The first situation would be when the property is an asset of the probate estate, which would mean something like an investment property or something that was not homestead of the decedent. In that situation, the personal representative would typically get permission from the court to sell the property without the permission of the heirs. If you have a will, you can actually give that power to the personal representative without having to get a court order. But if there's no will, personal representative will have to go out, seek a order authorizing sale of the property. They'll take the conditions of the sale, the purchase contract, the price and everything. They'll present those to the judge and get the judge's permission to get that property sold and to use those proceeds from that for the benefit of the estate and ultimately to go to the heirs. The more common situation is if you're talking about real property that was the homestead of the decedent. And because of Florida's homestead statutes, homestead passes by operation of law. So it's technically passes outside of the probate estate. This is kind of a complex area of law that's not too well known, so I'll try to just give a brief summary of it. But basically, if you have a homestead property in Florida, when the decedent dies, the heirs' interest vest by operational law. And if you can't get all the beneficiaries to agree to sell, you're going to have to partition, file a suit to divide up that interest and have the court sell the property and force that person to sell. And that could lead to a lot of different questions. So generally speaking, a partition is similar to if you owned a property with a friend, 50-50, and one wouldn't agree to sell, you'd go to court and you'd seek a partition. However, in Florida, the probate code, the law that governs probate, allows that partition to be done within the probate suit. So you don't have to necessarily file a specific separate partition suit. You can request partition in the underlying probate case, similar to how you would in a divorce case. If a husband and wife are divorcing and they can't agree on how to divide the property, you add account for partition, and basically the real property is sold by the court and then distributed according to the ownership.
Okay. So can the decedent's residence be sold before the probate is finalized by the court?
The decedent's homestead can technically be sold the moment the decedent passes away. Their interests vest in their heirs by operational law. And the very next day or the very next second, those heirs could then deed that property away. Very similar to how if one of those heirs had a judgment against them prior to this, that judgment would attach right away. So the analogy is, as soon as the decedent takes the last breath, their homestead property passes by operational law to their heirs in accordance with, the distribution we spoke about earlier. So yes, it can be sold. The practical part of that is most insurers, title insurers, when they're selling real estate, they don't want to have to take somebody's word for it as to who the heirs were. Because although the interest vests right away, who are these heirs? And that's where they'll often require an order determining homestead to be done within a probate case or some type of order determining the heirs. And so the easy answer to your question is yes, it can be actually sold before a probate's filed. It definitely can be sold before a probate's finished, but it's often required, or practically speaking, it's often necessary to file a probate and get an order determining homestead, which names those heirs. A judge kind of looks at everything and is giving the title insurance company some assurance that there's 5 heirs or 4 heirs, and commonly is sold well before the conclusion of the probate.
Okay, so who can legally sign a purchase and sale agreement and when? because this comes up all the time with investors.
We run back to the question of whether or not it was the decedent's homestead. And with the exception of a few caveats, if it's the decedent's homestead, like I said, it passes by operational law to those heirs, entitled the heirs at law. And those heirs would be the necessary ones to sign. When we're using the word heirs, we're going to interchangeably use that with beneficiaries. So the beneficiaries or heirs could sign and should sign the purchase and sales contract. John Doe dies and has no spouse and 3 children. Those 3 children would be vested with his homestead property right away. If you wanted to come and buy it, you should have all 3 of them sign the purchase and sales contract. If the situation is one in which the property is part of the probate estate, meaning the probate court's going to have authority over it, the personal representative or the executor is going to have authority over that property because it didn't pass by operation of law, maybe it wasn't their homestead. In that particular situation, you're going to have the PR sign. And the personal representative is going to be the one that's going to have the power to bind the estate. So how we break this legalese into practicality, you want to have as many people as possible sign. Oftentimes when you go up and you enter into a contract to buy the property and you determine that a probate needs to be done, there hasn't been a PR appointed yet because the probate hasn't started. You might even help the seller start that probate. So you're going to have the purported PR or the possible PR sign it. More importantly, you're going to have all of the heirs that you know of sign the contract. And you might not get it right as to who signed it, but it's going to give you a lot more teeth, a lot more actual power to enforce that if you had everyone sign versus just getting a minimal signature. If every beneficiary, heir, potential PR, have the whole crew sign. Somebody passes away, you meet with the children, have all 3 of the children sign if you can.
Yeah, I just had a transactional funding where on the A to B sales contract to the investor, there's actually 13 signatories. Those are all the proposed beneficiaries. And we just covered this, so to speak, but should each known beneficiary sign the purchase and sale agreement? And as you said, absolutely.
Yeah. And the interesting thing is when I do title work, obviously do real estate closings, the vast majority of the contracts, especially with probates, they're not executed correctly. But it's not an issue at the closing because in Florida, absent a few clauses in the contract that specifically state otherwise, the contract merges or disappears at closing. And the only thing that survives that is the actual deed. The way that works practically is have everyone you can sign it. It may not be the right person or the right way, but if you get to closing, it's not going to matter. And if you can't get to closing and you have to file a suit, you're going to want the more the merrier to have signed that agreement.
Well, let's talk about the obvious thing then. What happens if another heir comes forward after the property's been sold?
Well, we're going to go back to our 2 avenues. The avenue of it being a probate asset, meaning it was not the homestead. When it's not the homestead, the personal representative or the executor has the power over that, is the guardian over that property. And so if that was the first avenue where it was not the homestead and the property was sold and the personal representative signed the deed, whether that was because it had the power via a will or you had a court order authorizing the sale, then that beneficiary is not going to have any right or any claim. They're going to have to take anything that any issues they have up with the actual estate because that money flows through. If, however, it was homestead property, you need all heirs to sign because if there are 5 children and only 4 signed the deed, you have a lot of trouble. Regardless of what the probate court said, the probate court could have got it wrong. Maybe when they did the probate, they told the judge that there was only 4 kids. It turns out there was 5 kids. And so you're going to have a title claim. You're going to have an issue. If you purchased it, you're going to have an issue. If you resold it, that title company or that buyer, when they have an issue, they're going to come back on you. Because when you sell with a warranty deed, you're warranting the title's good. And then I guess you'll hope you'll make a claim on your title and policy. And obviously they'll step in and do what they have to do. But this is usually caught by the title insurer because they understand how important it is to have everyone sign. So what actually happens is if you're an investor and you're listening to this, the real key, the real takeaway from here is make sure you find out who all the heirs are ahead of time. Because if you do the entire probate and you missed an heir and the title company finds out, you're going to have to redo that probate. You're going to have to go backward and redo it. Or somehow you're going to have to find a way to get that heir to sign off. I'll give you a real life example. We had a situation where probate was done, an order determining homestead was done on the property. It was incorrect information was given that the decedent was married. I think his death certificate might might have even said married on it. So everything was done to give 50% over to his wife, or who we thought was his wife. And the reason why it was only 50% was how we go back to the other 50% went to his kids, because he had some kids that were not in common. But the underwriter, when they looked into it, they couldn't find a marriage license or something to that effect. So the underwriter looked up the obituary and saw that the obituary referenced the wife as his life friend, not his actual legal wife. And then ended up, believe it or not, calling the pastor or the church that did it and got more information and found out that they were never really legally married. So you had a court order here from a judge saying, hey, give 50% to this person, but now we found out that that was wrong. And so the question is, hey, can't we still close? We have a judge that says it. And the thing is, no, because under Florida law, homestead rights are established by the Florida Constitution. So nothing trumps that. So we had to go back, reverse everything, and unwind it and redo it. And that takes some time. And in these situations, you don't always have time if you have a pressing tax sale date or some other type of situation. What I would say, if you want to take something from this, don't miss an heir, because it's often discovered by the underwriters, the title insurance underwriters, because they understand how significant it is. And it's more likely than not going to set you back and make you restart the process again.
What happens when an investor agrees to purchase a property for, say, $100,000, but there are two or more beneficiaries?
With each question here, we're going to run it on two tracks. If it's on track number one, this is a probate estate. The executor has power. The executor, or personal representative, as we interchangeably call them, is going to be able to sell that property for the price that they agree to and move on. If it is a homestead situation, those two or more other beneficiaries are owners in the eyes of the law. So they're going to have to go and bring them back in and get them all to agree. And then if you can't agree or come up with some type of mutual agreement with every beneficiary of homestead property, you're going to have to get into a partition, which is where you actually divide out the interest. Let me break this back down. If you say you have 4 heirs and 2 of them agree to sell for 100, or three agree to sell for 100, and the other one says, no, I want $1 million. If you don't get that fourth one to agree, then you're going to have to buy the interest of the other 3 for whatever that is. It could be a proportionate amount, and partition out that fourth person.
And effectively, when you say partition, you force the sale of the property?
Yes. So what happened is, partition means that the property is, ownership can't be divided, meaning like a company, if you had 100% shares, you could just each take 25%. But with real property, you can't sell 3/4 of a house. So there's an avenue, which we call in law, called partitioning it, where the court actually takes the whole thing, sells it, and then divides up those proceeds and divvies them out based off the interest. Unlike a company where you could say each heir gets 25%, 3 of them could sell 75%. Well, you can't sell 75% of the house. So the court will sell 100%, and then they'll give 75% of the proceeds to the 3 cooperating and 25 to the other one. And so the way this works practically is, if you have an owner of property or a beneficiary of homestead property refusing to sell, you could seek the court to do a partition. And when they partition, that can be done. The court can sell the property either via a private sale, or maybe you guys come up with, the heirs come up with, someone they're going to sell it to, or one of the other ones buys it. Or ultimately, if none of those agreements can be reached, the court can sell it at auction, similar to how they would a foreclosure.
Wow.
And then the proceeds that net from that are divvied up based off of your interest. The interesting thing here in a partition, and why it makes it a pretty neat tool, is when you're refusing or you're holding out, not allowing to sell property against the wishes of the other owners, and you're sued for partition, the law in Florida allows the prevailing party to seek all of their fees if they win against your interest. So if 3 of them want to sell and the 4th does not, a partition can be filed. Upon completion of the partition and the property being sold, the money be divvied up, and the losing party, that 25% who would not sell, all the legal fees will come out of his portion before he gets the remainder. He or she gets the remainder.
Wow, that's extraordinarily powerful.
It is, because what happens practically is, you get to a situation where one person's withholding the right to sell. It's going to be sold. If ultimately it could be sold at auction, which we know auctions go for less than if you had it listed on the market, because for various reasons. And not only is that going to happen, but all the cost of these legal fees from these monsters we call lawyers are going to come out of one person's portion. Usually the only one who stands to benefit significantly in the partition are the lawyers, because they're going to get paid either way. And that normally gets the withholding person to cooperate a little more, unless they're just, unreasonable.
If you own 3/4 of the rights to the estate, I'm going to say there's 4 people and you signed up 3 of them, and you actually went to the auction yourself, you would know you're getting back 3/4 of the money that you're bidding. Am I wrong about that?
No, so what you're basically saying is if you're those 75% ownership, you have the uncooperative 25%, and now the court's going to sell it at the auction, and you're like, hey, man, this property's worth 200. We want to make sure it doesn't go for 100 because we're only going to get 75,000 versus 150,000 if it went for 200. Should I bid on it at 200 is what you're saying? Or should I do something at the auction to make sure it doesn't get undervalued? The answer is, yeah, you're going to get your proportionate ownership out of the proceeds. Interestingly, there was a slight change in the law that's to take effect. It's going to give you some type of, as the owner, some type of right to buy it instead of having to do what's commonly been done, where you basically have to go and make sure you bid enough to protect the property for not going for too short or too low of a price. Yeah, that's what has been done for years, is you're going to make sure whether you bid on it yourself or something, because you're ultimately going to get the benefit of your proportionate share of that.
Yeah, great. Well, as a final reminder, as I've always done, do not assume that because we talked about what seems like a similar situation to something you're doing, that it in fact is exactly identical. Again, comments or questions, have them addressed to info@myfllegal.com, and you'll get an answer back. Now, they're not going to give you legal information because they need to know more about your situation, but whatever they can do to help you, I know they will. Ryan, thanks very much again. Appreciate it.
Thank you, Dave, and I'm glad to give some advice when I can.
Thank you. Take care.